Good afternoon and welcome back to the Wolf Humanities Center ongoing series on the theme of choice. I'm Sophie Rosenfeld, project director for this year's theme and also a faculty member in the history department. And today I'm delighted to welcome you to what I think is going to be one of the most exciting and topical events in this year's calendar. That's a discussion among three leading experts on the past, the present, and the future of Roe v. Wade, and more generally, the idea of reproductive choice in the US. The moderator for this conversation today will be Serena Mayeri, a professor of law and history here at Penn, and an expert in family law, feminist legal advocacy, and law and social movements, including those connected to abortion rights. Her own 2011 book, Reasoning from Race, Law and the Civil Rights Revolution, has won multiple prizes in the world of legal history. And in the past few years, she's been producing a lot of terrific scholarship on the history and status of marriage. So you can see why she seemed the perfect person to lead this conversation. But first, before we plunge in, she will introduce our two esteemed guests, Linda Greenhouse and Reva Siegel. And as you listen to this three-way conversation, please put your own questions in the Q&A at the bottom of your screen, and we'll get to as many as we can before this session is over. Thank you to our guests. Thank you to our large audience for joining us. And I will now hand the floor over to Professor Mayeri.
Thank you so much. It's really a pleasure and a privilege to be here today with our two distinguished speakers who I've been fortunate enough for many years to have as models and teachers and mentors. And I'm thrilled to be sharing this conversation with them and with you today. I'm going to be much briefer in my introductions than their amazing CVs warrant, so as to save as much time as possible for our conversation. So we're incredibly fortunate to have with us today Linda Greenhouse, who's a senior research scholar at Yale Law School and writes a regular column for the New York Times, where she spent 40 years as a journalist, 30 of them as Supreme Court correspondent, coverage for which she won a Pulitzer Prize in 1998. She's the author of several books, including a biography of Justice Harry Blackmun, and in addition to many, many articles on the subject of reproductive rights and many other subjects, she is the co-author with our second speaker today, Reva Siegel, of Before Roe versus Wade, and several other works of legal scholarship about developments in abortion law. Reva Siegel is the Nicholas Katzenbach Professor of Law at Yale Law School. And in addition to Before Roe versus Wade, she is the author of path-breaking works of legal scholarship, too numerous to name, including many classic works on the history and law of reproductive rights and justice, and of progressive and conservative social movements. Her work has tackled the relationship between social movements and constitutional change in many different areas, including racial justice, gun control, pregnancy and work, suffrage, and motherhood. Without further ado, I'd like to begin our conversation today by just saying a few words about our topic and how it connects to the choice theme of the Wolf Humanities Forum this year. So choice has been one of the frames that some advocates of reproductive rights have used to articulate their demands for access to abortion and to other reproductive health care without state-imposed restrictions. And we've often talked of the pro-choice movement in connection with abortion in particular. And these topics are among our primary focus today. But choice is also implicated in our topic in another way that I wanted to mention, because both of our speakers have written compellingly about the politics as well as the law of abortion. So a recent Pew survey showed that 70% of Americans support Roe versus Wade, and 61% believe that abortion should be legal in most or all cases. And yet, of course, we have a Supreme Court and many state legislatures taking a very different path, arguably subverting both individual and collective choices, not only about reproductive rights and justice, but many, many other questions as well. So clear majorities of Americans favor a set of policies that are much more progressive than the ones that we currently have in a variety of areas, not just reproductive justice. And yet our institutions have become undemocratic enough that our elected leaders and now the federal judiciary have the power to effectively negate popular will and popular choices through their decisions. And what I think our speakers today will be able to speak to and have really shown us is the degree to which reproductive rights and justice have really played an outsized role in bringing us to this point, with opposition to abortion and to racial and gender justice, arguably pushing many voters to accept a much broader agenda in service of overturning Roe. And I think it's worth noting that in many other countries, from Ireland to Argentina to South Korea to Thailand, we've seen recent movement in very much the opposite direction. So on that note, I wanted to begin our conversation. Linda and Reva, your work together and separately on the history of social movements, of political contestation, and legal developments, I think illuminates really both of these meanings of choice. And you've shown how historically contingent and also how intertwined these political and legal developments have been. So I was hoping to start our conversation today by going back in time to the years before the Supreme Court's 1973 decision in Roe versus Wade. And as we've noted, movements for reproductive rights have sometimes used the rhetoric of choice to frame their arguments. And it's a frame that's drawn some criticism from many ideological and political perspectives. I think to those on the left, especially, choice might sound like a kind of anemic or neoliberal negative right to be free from government interference, but not to be entitled to positive rights to access reproductive health care and to have meaningful choices. But I think your work has shown, among many other things, that the language of choice is very historically contingent. And for example, in your historical work on the development of social movements, both for and against abortion rights, you've shown how before Roe, feminists really made a rich and creative set of arguments in courts and in legislatures and in the public arena about the centrality of reproductive control to women's freedom to pursue full and equal citizenship. And you've shown how many of those arguments, almost none of those arguments, were captured in the court's analysis in Roe especially. So I was wondering if perhaps you could begin by describing for us these more expansive framings of abortion specifically and of reproductive rights and justice more generally that prevailed before Roe versus Wade was decided in 1973.
So, Linda, did you want to start, or shall I jump in? What's good for you?
I just got a text.
Oh,
as I told the people running this, my daughter's in labor, and I just got a nice text that says she just dilated to 10 centimeters, and they're calling in the doctor. So that's all good. Reva, why don't you?
Okay, I will start.
Well, while I have the floor, let me just say to Serena the word choice, and then we'll get back into the historical stuff. The word choice itself really is contingent. It was not a word that the feminist movement used, actually. It was developed in response to pro-life, which was the slogan that had been grabbed by the other side. And it came out of one of the abortion rights kind of think tanks, not really an advocacy group, around the period of Roe. And when Reva and I worked on the book that Serena mentioned, the Before Roe book, which is basically a documentary history, we found the memo that said, they have pro-life. We need something. We need something on our side. How about pro-choice? And as Serena said, it's a not unfreighted word that does connote, it connotes a kind of casual, let's choose. I woke up this morning, let's choose an abortion. And it also, it buries the notion that the claim was for women to have the autonomy, the agency to choose between motherhood and not motherhood as something a much richer claim than simply choice. But I'll turn it over to Reva for some more of the history.
So knowing that Serena, first of all, I wanted to say thank you to the Humanities Center for this invitation and for this opportunity to be with people whom I adore, and with my hands clenched here for Hannah on the West Coast. So let me just say that in thinking about a place to start to summon this time before Roe, which Linda and I decided to investigate when Roe was already convulsed with conflict. So we wanted to know something about origins. One of the accounts of choice, I'll put it in scare quotes, that we pulled up in the course of doing that first book, and a short take on it, which we included in a reader, Reproductive Rights and Justice Stories, that's in Foundation Press, and which also features an amazing story that we wrote about Roe, Serena wrote about Casey, which we grabbed to put in that chapter, was a quote from Betty Friedan, which I think captures at least a feature of the choice situation in much more historical contextual perspective. She says, there's no freedom, no equality, no full human dignity and personhood possible for women until we assert and demand control over this choice. She says, women are this is in 1969. Women are denigrated in this country because women are not deciding the conditions of their own society and their own lives. Women are not taken seriously as people. Women are not seen seriously as people. So that's the new name of the game on the question of abortion, that women's voices are heard. And you can hear in that account of the decision something that's both saying it matters viscerally and practically to the individual woman in question, but it also matters because of women's general social status, their lack of voice or authority politically in the society as a whole. And when I was looking at that quote, I sort of dug around, and sort of at the time that Friedan is saying this in the late 60s, and she's not the only one who's beginning to raise not the question of decriminalization, but the question that decriminalization was an issue of constitutional moment for women for a variety of reasons, which different reasons women give different accounts of. She emphasizes this at a point at which there's about 1% of the federal judiciary that are women. I looked back at Frontiero, which is one of the early sex discrimination, equal protection sex discrimination opinions that comes down in 73, which reports there are no women in the Senate and there are 14 women in the House at that point. So there's just some sense in which, yes, it's about a particular practice of immediate practical implications for individual women and for women as a group and for subgroups of women who are differentially vulnerable to harm under conditions of criminalization. But it also matters symbolically because of women's not formal exclusion, but practical exclusion from political authority that's mirrored in their being deprived of control over these kind of questions.
And let me mention one other contingent aspect of the way things evolved. So at the time that Roe, the case Roe from Texas, was making its way through the courts, so were a bunch of other cases because the moment had come. And it just was a matter of contingency that Roe got to the court first. And it outran a case that actually would have at least focused the court's attention with more intentionality on these broader claims. A case that came to be known as Women Against Connecticut, a case called Abely against Markle, that was organized by a group of female law students at Yale and professors. And they went around and took testimony from hundreds of women about, why do you feel you need access to control your reproductive life? And all these testimonies went into the record of this case. And it really would have been a wonderful case, much richer. Roe was kind of as a legal matter, kind of slapdash effort, and reached the court in 1971, court of 9 middle-aged men. There had obviously never been a woman on the court. And to the extent that these voices that Reva talked about were legible, I mean, they were presented in amicus briefs. There's some very out there amicus briefs with claims about 13th Amendment slavery and other things. All that was there, but these were not judges who were capable. I mean, not only weren't they willing, I don't think they were capable of hearing and of assimilating those voices. And so what we got was, in January of 1973, a decision really about the rights of doctors. The court was speaking to its peer professionals and the other profession of law, of medicine, and they were very concerned that doctors acting in, to assume, the best interests of their patients shouldn't face prosecution in jail for doing what they thought was right. And if you read Roe, and people don't read it actually, but it talks about the woman in consultation with her physician, and it's going to be the doctor who tells her what's in her best interest. It's really to read it today. You're left kind of shaking your head, but it's a window into how the world saw the issue at that time.
Well, one way of understanding what happens here is that there is a case, maybe people read it in Con Law Griswold, the right to privacy case that concerns or that struck down a Connecticut statute that criminalized contraception and did so in the name of a right to privacy derived from a penumbra that was like a reading of the emanations of various pieces of constitutional text. There was no equal protection law to speak of for or prohibiting sex discrimination. And the question is, if the Constitution is going to proscribe laws that criminalize decisions about childbearing, what's the authority on which that rests? Justice Blackmun and the other 7 justices invoked this right to privacy, and they read it through the authority they thought of science. And much of Roe is written in that language. But when the women who were organizing in New York and organizing in Connecticut in a group-based way to try to push for change before, in the years preceding Roe, spoke about the question, they appealed to their own experience. And so the difference between these early cases, which lack legal authority, and the later ones, which have legal authority, is that the early ones are reasoning about the life circumstances of women. And they're speaking and they're quoting depositions of women's voices and the harms to women, whether because the question of criminalization deprives women of control over relationships, denies them access to school, because in those years, women were thrown out of school if they were pregnant out of wedlock, or denies them access to jobs because there was, if we have any discrimination, protection against pregnancy discrimination now, which is scant, there was none then. So the stakes were really high, and they spoke about it in fairly concrete terms and incorporated these kinds of accounts of injury and inequality and injustice into the briefs. It's true that the case we know as Roe, litigated by Sarah Weddington, did not use this kind of movement-based reasoning in making its way to the court, but others did, and that's why it's in the amicus briefs. And I just wanted to also just read you a snippet from the Connecticut case that responded to the story that Linda is telling. The judge there, when the judge first struck down the Connecticut statute that criminalized access to abortion from the late 19th century, the judge said that Connecticut laws take from women the power to determine whether or not to have a child. These statutes were enacted in 1860 when we thought of women in a certain way and didn't give them the vote. But he says their status in society has changed dramatically. From being wholly excluded from political matters, they've secured full access to the political arena, or so. Now some 30 million women comprise 40% of the workforce. And as women's roles have changed, so have societal attitudes. The recently passed Equal Rights Statute, by which they mean the amendments to Title VII and 72, and the pending Equal Rights Amendment demonstrate that society now considers women the equal of men. So these voices did get through to that judge in a way that they weren't even presented squarely to Harry Blackmun.
Actually, this prompts me to, maybe this is a digression, but it reminds us how important judges are and who gets on the bench. And this judge, whose name was John Newman, he's still a judge on the Second Circuit. He's a senior judge now. He's in his 80s. He's still brilliant. He clerked for Earl Warren, Chief Justice Earl Warren. He was a baby judge then. It was one of his very first cases. He was in his 30s. He had never spent 5 minutes of his life thinking about abortion. He got this case, and I've talked to him about it over the years, and he was terrified. What am I supposed to do with this? I don't know a thing about this. And so, but with a totally open mind, and obviously a kind of a liberal, small L liberal, interest in the world he was living in, he dug into it and he came out with this amazing opinion. And it really matters who's on the bench. I'll just say that.
I think that's a great sort of segue into thinking about what you've already discussed, some of the obstacles to realizing these more expansive arguments in the early days of Roe and the other cases that were percolating through the courts at that time. I'm wondering if you can tell us more about the politics of abortion in the years following Roe and the role that it played, that you've written so compellingly about, in the partisan realignments and the changing composition of the court, so that, which is a much longer story, of course, that leads up to the present day. But I'm curious if you can tell us more about the kinds of counter mobilizations that preceded and succeeded Roe.
Let me just, I'll briefly and then turn this over to Reva, but just kind of set the stage, the kind of counterintuitive stage of what the landscape was like on which Roe landed in January of 1973. Abortion was not perceived as much of a political issue. So Richard Nixon had 4 appointees to the Supreme Court, and 3 of them, including his very conservative Chief Justice Warren Burger, voted with the Blackmun. Well, Blackmun was a Nixon appointee. 3 of the 4 voted for the right to abortion. And of the 2 dissenters, one was a Nixon appointee, one was the one John F. Kennedy appointee on the court, Byron White. And polling in those days shows us that the right to abortion was really embraced by Republicans. When Gallup asked people, in the summer before Roe came down, in the summer of 1972, do you think that abortion should be an issue left to a woman and her doctor? About the majority of the population said yes, woman and doctor, without government intervention. But the largest single group were Republicans. They were the party of reproductive choice. And so I'll turn it over to Reva to say, how could we go from there to where we are now?
So there's no doubt that there was conflict before Roe and there was conflict after Roe, but it just didn't have the shape that we know it in its modern form. As you can tell by Linda's account, the fact that, if anything, the party for decriminalization was the Republican Party. And we know that in the period both before and after, the leading opponent of decriminalization was, I'm not sure how to express it, whether I say it was the Catholic Church, the Catholic hierarchy, Catholics. In point of fact, the numbers in the Gallup poll that Linda's talking about show more than majority support amongst Catholics for decriminalization in this time period. But it's without a doubt that the United States Conference of Catholic Bishops played a role in organizing and articulating and funding resistance to state laws that are decriminalizing abortion, and this continues after. But the big key dramatic shift in this conflict that's like pouring gasoline on a fire is the interest of the Republican Party in potentially using the arguments around abortion to recruit Democrats to the Republican Party, or what it's sometimes called realignment. So at this point in time, Catholic Americans were predominantly voting in the Democratic Party. And of course, within any religious or any community, there's different intersecting political alignments. Some of them are more conservative than others. And of course, you'd have to ask across what issues. I mean, the issue of class and race and family and religion are not all as perfectly aligned as they are today, or they're differently aligned. So the Republican Party began to switch positions at the top level, not at the base, began to switch positions on the abortion issue in an effort to coax Catholic voters into the Republican fold, one, and two, it began to do so by telling stories about abortion that begin progressively to emphasize the gender politics of the sorts of very issues that Friedan and Flo Kennedy and Nancy Stearns and others in this era are talking about, namely to make salient to people's mind, not just simply women's practical needs in the circumstances, but the symbolic practical stakes of giving women these kinds of control. And it so happens that this is also going on concurrently with, as we heard, the debate over the Equal Rights Amendment. So it's not like this is the sole issue around the question of gender roles that things are hot. To the contrary, there's a mass mobilization across a number of fronts. And this begins to forge or highlight or imbue the abortion debate with the family wars question, the way in which we know it today, modernize the debate into its contemporary shape. And as this happened, this is not something that happened immediately when Roe was handed down. So it can't be said that adjudication was the primary or the sole causal mechanism. And it wasn't even immediately the mechanism in the sense that it happened over the ensuing 10 years, basically. But one of the things that happens is the Republican Party begins to coax Catholics to the fold and create a new coalition with evangelical Christians over the abortion question, which is an issue that can be argued about in politics in a way that faith can't be as directly. And whereas before there had been tension between the Southern Baptist Convention, which hadn't come out against Roe, and the Catholic Church, because there was some degree of sectarian hostility or prejudice or something, I guess we can say. This abortion issue, aligned with a set of issues around the family and gay rights, and all of this comes to be the new pro-family agenda. And when abortion is framed in that way, we've created a new fault line in which there's a division between the sex lib group on the one side and social conservatives on the other. And that's much more the meanings of the abortion debate that we know today. Otherwise, it's hard to know why LGBT issues are tangled up with abortion. If it's solely an issue about when unborn life begins, what do the two issues have to do with one another? It's because of the questions of sex and sex roles that are entangled in the debate as well, that it has this powerful symbolic significance. But in any event, what we can see here is that the political party and ordinary democratic politics played a role in refashioning our understanding of the conflict of abortion and heating it up, supercharging it with other sets of concerns that made it central in a way that it hadn't been. We point out that at the point at which Justice Stevens was confirmed 2 years after Roe, there was not a single question posed to him about Roe. So in 1975, it was not the question that it then becomes by the time of Reagan's election in 1980.
And I'll just say that maybe transition to our next topic. So one thing that happens is the Republican Party, not in 1976, which would have been the election cycle right after Roe, but in 1980, the party platform pledges the Republican presidential candidate, who ended up being around with Reagan, to work for the appointment of judges who would stand for, I forget exactly the phrasing, but innocent human life or whatever. It was an traditional family values is the other half. It was an anti-abortion plank in the platform that tied it to the appointment of judges. And so that really started us off to the races with our judicial politics that have been so infused by the abortion issue. It wasn't what people assume, which is, the court, and that's the real meaning of the narrative that Reva just gave us. People assume Roe comes down in January of 1973, and by February, the country's ablaze with backlash. No, it was cultivated, and the Supreme Court was designated as a target over a period of years. It wasn't obvious to people at the time that the whole narrative looked at from the perspective of 2021 is really different from the way it actually unfolded, which is a fascinating thing about history.
One thing I would just add to this is that we're so used to thinking of judicial nominations as the vehicle by which parties exert their will in the arena of Supreme Court decision making. But it was really the Reagan administration and the Meese Justice Department that elevated sort of selection of judges with attention to their orientation and disposition to decide particular litmus issues to a really high level. And they selected the abortion issue as kind of a key litmus test. They were not only interested in questions of abortion. As I was saying, the party platform said innocent human life and traditional family values. And so there was an interest in a set of questions that included the boundary between church and state. And then sub rosa, a set of issues, I think, also about race relations, which were no longer legitimate to talk about as a target in judicial appointments. But I've always observed that after the Reagan appointments, the law on race discrimination changed faster than the law on abortion. So there was something about the Meese Justice Department appointments, its selection process, that really zeroed in on judges with hostility to busing and hostility to anti-discrimination law and employment discrimination law, as much as, if not more than, the issues having to do with choice.
So this really fascinating account of history, I think, shows us the degree to which the courts were key actors, but not necessarily in the way that we normally think of them as such. And so after you've given us this narrative, I'm hesitant to focus again on another Supreme Court decision. But I wanted to bring us a little bit forward in time, but not too far forward for a moment, to talk a little bit about the 1992 decision by the Supreme Court in Planned Parenthood versus Casey, which you've both alluded to, and use that as an opportunity to talk about how anti-reproductive rights and justice advocacy has evolved over time. And Reva, you've written about changes in the way that anti-abortion advocates reason about abortion rights, and in particular, the way what you've called woman protective arguments have developed. So I was wondering if you can tell us a little bit more about the rise of those arguments in recent decades, and maybe that can lead us into thinking about the current landscape of abortion restrictions and how that's evolved.
Okay, well, this is a lot. I'm going to try it in maybe two steps. Really, you should be telling us about the Casey decision, since I will once again commend the audience to your amazing essay on the case. Casey was a case decided in 1992 I'm going to be very brief about this because otherwise we won't get to the present. But Casey is a critical case decided in 1992 after the court had already been reshaped by both Reagan administration and Bush administration appointments, the logic of which was to push the alignment of the justices on the court in such a direction that everyone expected Roe to be overruled. And everyone was hanging on the decision with bated breath, expecting that was the end. And that's what makes reading about it today so fascinating, because it's not all that far from where we're sitting now in 2020. But the decision comes down, and the court both affirms, with a surprise decision, both reaffirms Roe and narrows it dramatically and rejustifies it. So what do I mean by all those things? Briefly, we can go to the law a bit more particularly later, but it first of all did not reverse the Roe decision, even though there were these conservative justices on the court. Some of them stepped forward, perhaps most prominently, Justice Kennedy, and also Justice O'Connor, the first woman nominated to the Supreme Court, to restate and narrow the Roe decision. And they did this by allowing regulation of abortion decisions in the interest of protecting potential life throughout the pregnancy, rather than requiring the state to withhold that kind of regulation until the point of fetal viability, much later in the pregnancy, one. And two, they said, however, we're going to balance this new authorization of abortion restrictive regulation in the interest of protecting potential life against a restatement of women's right to choose. And the court said that you could not impose on the abortion decision laws that created an undue burden and on the decision. That's laws that had the purpose or effect of imposing a substantial obstacle on a woman's choice. The meaning of that being, you could attempt, for the first time, the law allowed government to try to dissuade women from having abortions, but it couldn't obstruct or prevent their decision. So inform them, not hinder them. That's the core principle of Casey. And when it said why this was so, even though it was still reasoning at the Liberty case, everything it's saying about abortion is shot through with concerns with women's equality in a way that Harry Blackmun and the Berger Court couldn't hear 20 years earlier. So we won't go through all of the expressions of this in the opinion, but without formally shifting grounds to equal protection, the court kept giving as reasons its decision to stand by this right, the fact that women were equal citizens and that control over this decision was necessary to their equal participation. Okay, so I just said that very quickly. So there's a shift, there's a reaffirmation of the decision, a narrowing of the scope of the right, but a restatement of it and a justification of it that says, actually, you can't control women, you can't just obstruct their choices, you can't instrumentalize them as objects for bearing unborn life. You actually have to dissuade them, you have to address them as agents, you have to treat them as dignity-bearing persons who have to be reasoned with, not merely controlled. Okay, so what happens? Well, in the wake of this decision, the anti-abortion movement at this point, having gotten as far as to set up nearly a court to overrule Roe, is in a state of shock and depression. And also in '92, Bill Clinton is elected. He's the first president that is openly supporting choice or supporting women's access to the abortion right. And there's deep concern in the anti-abortion movement that its particular way of arguing about the question, which is sort of when does life begin? We have to protect the unborn, is not going to cut it in a world in which there's increasing recognition, however cabined, however qualified, that actually women's welfare and their agency and dignity matters in some way. And so you begin to see in this time period a remarkable shift in the way in which the anti-abortion movement is arguing its cause. Before, it either focused solely on protecting unborn life and then said a bunch of very traditional things about the family, what I was calling pro-family before, or it just simply didn't even speak about women and talked about the whole question as if it were solely defined by the ontology of the unborn. But now it starts to reason in a very, very different way that it calls, in a movement-based way, pro-woman, pro-life. And in this new expression is offering itself as protecting women's interests in the form of denying them access to abortion so they can realize their true natures as mothers. So when stated in that way, you can see that the emergence of the pro-woman, pro-life position in the anti-abortion movement is this fascinating modernization or hybridization of a bunch of political claims, some of which are the old anti-abortion claims, some of which are the old women's roles claims, the pro-family claims, but then it's mixed up with a lot of feminism talk and rights talk. And so the way to have equality is to criminalize abortion so that women will be healthier and freer. And that's a little confusing because we thought that it was choice that was going to give women autonomy and security and health. But these set of claims are turned upside down, just like in the race case, the position against affirmative action became known as colorblindness. So too, a lot of pro-choice talk is taken and used as frames for arguing for the criminalization of abortion. And I'm going to just read you I could read the Wilkie quote, which is really fascinating, but I'm going to just read you one story I've written about. Well, here's a story from Mother Jones in 2001, and I'm just going to read you just an excerpt from the story in 2001. The Casey decision started abortion opponents rethinking their tactics. Since direct assaults on Roe wouldn't fly, there, quote, had to be a shift in strategy by regulation on the outskirts of abortion, says a woman named Dorinda Bordley, who is working for an organization called Americans United for Life, which is the group that is the premier generator of anti-abortion statutes. That's when leaders developed a new approach, couched the issue in terms of women's health. So this is, they're recounting their shifts in the 90s after Casey. By claiming that abortions take place in dirty facilities and cause illnesses like depression and breast cancer, Right to Lifers realized they could suddenly move the focus of debate. And here we go, Bordley again. For 25 years, the pro-life movement focused on the baby and the abortion rights movement focused on women. The baby and the woman were pitted against each other. What we've realized is that the woman and the child have a sacred bond that should not be divided. What's good for the child is good for the mother. So now we're advocating legislation that's good for women. Now, the reason that this is abortion restrictions are good for women, the reason I picked this quote from Dorinda Bordley is that she is the woman who, working for another anti-abortion organization, helped introduce the admitting privileges statute to Louisiana that is at the heart of the June medical decision that the court decided last term. So just so that you can see the lineage here, I was quoting her from 2001, explaining how the organization had adopted this pro-woman, pro-life perspective, but she is continuing. She's a very prominent, very effective, and well-networked activist. And she's continuing in this work decades later and played this quite central role in getting enacted the statute that the court struck down last summer under the name of June Medical. So maybe Linda could tell us a little bit about the modern admitting privileges laws and trap laws and the like.
Yeah, so Reva just used the phrase trap law. So that stands for targeted regulation of abortion providers. And that means that within this pro-woman, women's health mode, you impose on abortion providers the kinds of regulation that you never thought to impose on doctors or clinics that perform other kinds of medical procedures of equivalent risk. That is to say, with abortion, we know the risk is very low, and all kinds of other procedures of higher risk, like a colonoscopy or arthroscopy or whatever, a doctor doesn't need admitting privileges, and all of a sudden, out of this Americans United for Life crucible of really, brilliant anti-abortion strategies comes this admitting privileges law. Why is that so effective? It's because to require a doctor to have admitting privileges, you've got to satisfy a hospital to let the doctor in, and both for religious reasons. A great number of hospitals in this country, I think it may be as many as 30%, are Catholic. For anti-competitive purposes, hospitals are very loath to grant admitting privileges unless the doctor will actually admit patients, which of course doctors who perform abortions don't. Anyway, to make a long story short, abortion providers and clinics cannot meet this requirement. When this requirement came in Texas, in the case that became Whole Women's Health, half the abortion clinics closed, and most of those have never reopened. So this is a prime example of the trap law, and the way the Supreme Court in Whole Women's Health, a decision, opinion written by Justice Breyer, in 2016, it was an 8-person court at that time because Justice Scalia had died. And as we know, the Senate was not willing to confirm Merrick Garland, so there were only 8 justices on the court at that time. Use a kind of a new rubric for evaluating laws of this kind. Justice Breyer said undue burden is the standard. We know that from Casey. Well, how do you know if the burden's undue? You need some kind of comparative analysis. Undue compared to what? So what he balanced was the burden, undue burden, against the benefit that the restriction or the regulation provided. And if the burden was great, that is to say, shut down half the abortion clinics in a state, and the benefit was minimal, that is to say, doctors who provide abortions almost never end up having to send patients to hospitals, the burden is undue. And so the Texas law was struck down. Now we're in a very troubling, fascinating, consequential period because Louisiana had exactly the same law as Texas did. And Louisiana, like Texas, is in the Fifth Circuit. And the Supreme Court in Whole Women's Health overturned the judgment of the Fifth Circuit that had upheld the Texas admitting privileges law. Louisiana comes along and its case gets up to the Fifth Circuit, and the Fifth Circuit says, yeah, we know that we were overturned in Whole Women's Health, and we know that this law is identical to the law that the Supreme Court overturned in Whole Women's Health, but you know, that was Texas and this is Louisiana, so we're going to uphold the law here. So what does the court do? This is a crisis for Chief Justice John Roberts, who was in dissent in Whole Women's Health. But he's got to strike down the law because stare decisis, the respect for precedent, and respect by a lower court of the Supreme Court is really essential to the working of our system, the latter more than the former, actually. So John Roberts has to find a way to strike the law down, which he does. Justice Breyer writes the opinion. Roberts does not sign that opinion. He joins the judgment. He says as a matter of stare decisis, of course this law is unconstitutional. But by the way, I didn't like Whole Women's Health 4 years ago, and I still don't like Whole Women's Health, and I don't believe this balancing test is a proper reading of Casey. We don't have to look at the benefit. All we have to look at is the burden. The question now is, what's the law of abortion? Because Whole Women's Health and its interpretation of Casey, which had 5 votes in 2016, now has 4 votes. So the lower courts are all over the place in what weight to accord the Roberts concurrence in the judgment and what is the law. The case came down from the Sixth Circuit 2 days ago. Very fascinating case. I have it right here. It's called Bristol Regional Women's Center against Slattery. Brilliant opinion written by Karen Nelson Moore on that court 2-1 panel. And the only question was, so the state of Tennessee put in a 48-hour waiting period requirement. The woman has to go in person to the clinic, get a whole rigmarole read to her by the doctor, by law, and then has to come back 48 hours later, having thought about it for 48 hours to get the abortion. The district court struck the law down. The question for this panel that ruled 2 days ago was, shall we grant a stay pending appeal? They grant the stay. The dissenting judge, Judge Sarpour, said, wait a minute, in Casey, in 1992, Casey upheld a waiting period requirement in the state of Pennsylvania. So we know, A, waiting periods are per se constitutional, and B, we read the Chief Justice's opinion in Whole Women's Health as taking a much more state-friendly view of the matter of regulating abortion, and so the law has changed. What Judge Moore said was, Casey did not set a per se rule. Casey upheld the waiting period in Pennsylvania, which had 81 abortion clinics at that time. Tennessee has 8 abortion clinics, concentrated in a couple of cities. And for many women in the state to have to make 2 trips within 48 hours across the state to find their way to the clinic is an obvious undue burden. And Chief Justice Roberts' opinion is not the opinion of the court. The opinion of the court is still whole woman's health, and so we grant the stay. What this 2-to-1 opinion tells us is we're really off to the races, and there's no way the Supreme Court is going to be able to avoid getting back into it. I say able to avoid, not that they necessarily want to avoid. They may well want to get back into it, and this case may provide a platform. There are a lot of other cases floating around. For months now, the court has had on its docket and has taken to the Justices' Weekly Conference 6 or 8 times a case from the state of Mississippi, which passed a law saying falsely that because fetuses feel pain at 15 weeks of pregnancy, not true, but they say that anyway. That's the world we're living in now. We hereby ban abortion at 15 weeks, which is pre-viability. And one thing that the Casey opinion said that the court has not entertained a challenge to since is the cutoff is viability. That a woman has an absolute right to choose an abortion of the fetus before viability. So this case has been, so this circuit, of course, had to strike the law down on stare decisis grounds. Mississippi has appealed, and the case has been carried over week after week after week. The Justices' Conference, which suggests, obviously, there's some big internal dispute going on. Somebody's writing something. They're either writing a dissent from the court's decision not to hear the case, or they're trying to cobble up an opinion to decide it in some per curiam fashion, in what's called the court's shadow docket. I don't know, but that's pretty interesting. That's just one of the things that's going on right now.
So one thing I can just say about this sequence that you've just heard is that if you want to follow what's happening here, there's at least 2 ways of understanding how the law can deny access to abortion or restrict women's choices. One is directly, if the state adopts a ban that just simply says at 15 weeks, no doctor can perform unless they're subject to some kind of criminal liability. So that's the language that we're used to looking for overruling Roe, where there was a holding that you could not take the choice from a woman in consultation with her physician before the point of fetal viability. Will the court break that barrier and allow a state to pursue a fetal protective restriction on abortion that is in direct contradiction to the rulings of these earlier cases? The other way in which the court can take things apart is by the kind of indirection that Dorinda Wardley, our friend all the way back in the Louisiana story, was specializing in, where the court would turn away from or not closely scrutinize the health justifications for laws that, in fact, single out abortion for burdensome and unnecessary regulation, to use Casey's language, in the interests of imposing such regulatory burdens, trap laws on clinics, that they begin to shut down because they simply can't either find the resources or literally can't manage to meet these burdensome restrictions. And the state can, without ever adopting a formal ban, adopt a set of civil regulations, civil and criminal regulations of the practice of abortion that are so onerous that the existing infrastructure of healthcare provision is whittled down and eviscerated to a point where there's a practical access issue. And we already are in a world that is not unlike the world before Roe, where women's access to a safe abortion depends on their resources and status, their ability to negotiate the legal system, rather than it being a decision that's available to all independent of class and social position. And I will simply say that we're certainly moving swiftly on this latter front, the trap law, faux healthcare, regulatory obstruction front, in that direction. We don't know how fast the court is going to actually move in the formal overruling mode. That's a question that is to be decided by a bench now that no longer turns on just Chief Justice Roberts' vote, but also because of Justice Ginsburg's passing and the confirmation of Amy Coney Barrett, there's potentially 6 votes there. Maybe not for every conceivable regulation of abortion, or possibly so. 6 votes there to change the law. And the question will be not simply in the judgment of Chief Justice Roberts, but in the judgment of this more, potentially more intemperate wing of the court. How fast are they prepared to dismantle a right that nonetheless enjoys the kind of confidence of Americans that Linda had talked about and Serena had talked about at the beginning of this conversation. So that's the path to follow. We don't know how fast and exactly through what avenues this is going to happen.
So we've been talking about the ways in which abortion rights have been restricted by state legislatures, increasingly upheld by the Supreme Court. And I'm wondering if we can expand our conversation beyond sort of the anti-abortion restrictions that I think are on everyone's minds, and think about our very current political situation, where we have this very conservative court on the one hand, but on the other hand, we have a new administration. Barely we have a Democratic Congress. We also have a number of state legislatures and state courts that have already gone in a different direction, in a more progressive direction to attempt to expand rights to abortion specifically, and also access to reproductive health care more generally. And of course, we also have reproductive justice movements that have looked beyond abortion, as you've mentioned, to think about more broadly about what would be necessary for all people to be able to have meaningful choices about their reproductive lives. So I'm wondering, and I know, Reva, you've written about a pro-choice life position that takes a more holistic and affirmative and even redistributive approach to reproductive justice. And I'm curious what both of you think the prospects are in this new administration and with a new Congress, what the prospects are for this more affirmative agenda for reproductive rights and justice.
Maybe I'll just speak very briefly, and then let Reva talk about the pro-choice life approach. But certainly the Biden administration is well aware of what it needs to do in this area. I think it fully intends to do a lot of the damage that's been done at the federal level has been done by executive order and regulation. And so these are things that President Biden can undo. He's already undone, as I understand it, the Mexico City policy, which is a very restrictive anti-abortion policy about federal money flowing through international NGOs that work for maternal health, and really very important in the Trump administration. I'm sure caused the morbidity and mortality of thousands of women by pulling federal dollars out of those programs. So I think there's a lot of hope at the federal level. On the state level, some of the states are just. I'll give you one example that came to my attention just today, and then turn it over to Reva. There's a bill pending in the New Hampshire legislature that would cut off state money to college-based student health services in the state unless those student health clinics pledge not to discuss or refer out for abortion. Okay. This is public health as we know it today. But Reva, over to you.
So I'll just, in the interest of making time for group conversation, I will just say a few words about the critical perspective to which Serena had just referred as a context for thinking about legislative choices and legislative strategies in an era where our federal judiciary is no longer likely to provide significant protection, if any, to women's decision-making in this area. So Serena had talked about some work of mine that I framed under the name of Pro-Choice Life. And what's that? It sounds like some of everything. Perhaps by reading in the history of social movement struggle over abortion issues and watching how it was that the right claimed left frames, it occurred to me one can simply ask, what does it mean to be pro-life? And so the beginning of this inquiry is simply the insistence that whatever it means to be pro-life couldn't start and stop with a view about abortion. But that is in fact what we equate being pro-life with, that is to say a position in the abortion debate. The stance that I've assumed now for some number of years, initially as a thought about how to argue before courts, but very quickly as a view about what's to be said in political spheres, regardless of whether there's a judge left to appeal to, is the idea that we shouldn't take at face value what states who are adopting abortion restrictions say about the values that are funding their abortion restrictions, whether they're making claims that they're doing so to protect women's health, or whether they're making claims on the grounds that they're interested in protecting life. Before we're obliged to credit this claim, I'm not saying it's in bad faith, but the simple question you can ask is, are they acting in other contexts in ways that are reasonably consistent with the way they're acting in the abortion context? And how does expanding the frame to consider their policy choices in other settings illuminate the underlying logic of the abortion restriction? And I started to ask these questions because faced with a number of often Southern, although not always Southern jurisdictions, that were adopting abortion restrictions, in fact, had an incredible appetite for abortion restrictions, like Louisiana, the state that was litigating its admitting privileges law in in June Medical, which had won the status of most abortion restriction friendly jurisdiction in the United States from Americans United for Life for year after year after year because of the number of abortion restrictions that it had. But at the very same time that it was adopting the admitting privileges law that was going to shut down many of the clinics in the state, if not most of them, it was also refusing Medicaid expansion. And it further was in refusing to provide sexual education as part of the curriculum in high schools, much less provide access to contraception. So the question becomes, what exactly, first of all, do we have any reason to credit that an abortion restriction is for women's health when there's no significant interest in providing for women's health outside of the abortion context? It's not that there's none, but when the policy choices of the state are compared to other states, they are at the bottom of the barrel. And also in terms of outcome measures, very, very high maternal mortality and infant mortality rates in Louisiana, which are not just the result of poverty, but they're also the result of policy. And the result of policy that's justified in ways that are not singing praises of life, but rather talking about the deserving and the undeserving and equating success with pushing people off of public support. So the question is, what do we make of that morass of policies? And do we want to call that pro-life? We're not obliged to. We're entitled to contest whether it's for women's health or for protecting unborn life. And we could talk about other policies that would actually reduce the women's interest in pursuing abortion, like, for example, providing them resources so that they might be in a position to make different choices about their family lives were they so moved. Why is it that Americans United for Life never provides income transfers amongst the types of policies that we consider providing for reducing abortions, but only punitive policies? So that's the kind of inquiry that I'm talking about here. It can be played out on many scales, local, state, or national. It can be used as a critical device, namely a way to question the values that are informing abortion restrictions as a matter of politics, even if they're not judges to hear the claim. But it also can be used in a constructive, forward-looking way to look for realigning coalitions to split the pro-life community into different forms of pro-life advocacy. Are you, as a pro-life person, only interested in ending what you call intentional life-taking, but have no care for the well-being of the women and the children into whose lives you're intervening? Or are you, nuns on a bus, are you the kind of pro-lifer who actually has a care ethic funding your views about abortion that leads you to be prepared to support healthcare and support resources, including work-family accommodation and other interventions that would redound to the human flourishing of the persons you're otherwise prepared to regulate? And I think that's a conversation. I would call that purple politics. You know, can we find ways to make common cause across party and movement lines with those with whom we may perhaps fundamentally disagree as to some questions, but can find reasons to agree or converge on other grounds? And to what extent are there persons in the contemporary pro-life movement and in the ranks of the Republican Party that are prepared to have a more expansive conception of what it means to genuinely act for life? And if they can't find their way there on sex ed or contraception, what about healthcare? What about healthcare? What about work-family issues? What about, I mean, if we really wanted to scale up, what about the environment? What about, you know, we could do a lot of what abouts. So I'll stop there.
And can I just say, I know you want to turn to the questions, but you know, this isn't just pie in the sky. A few years ago, there was a pregnancy discrimination case at the Supreme Court brought by a woman who was a driver for UPS. And UPS drivers are expected to be able to lift, I think, 70 pounds. She had a complex pregnancy and her doctor told her not to lift more than 10 pounds. And she asked for the same kind of accommodation that male employees got for their various problems. And she was told no when she brought a lawsuit. And among the amici, among the friends of the court who came in on her side were pro-life groups, because they saw it as, you know, they wanted some way to ensure that women in the workplace could, if they chose, and of course they hope they would choose, to carry a healthy pregnancy to term. And so, you know, that's really an example, and it was a kind of a simple one, and she did win her case more or less, of unexpected, a kind of strange bedfellow coalition that can come together if it's framed properly and with some imagination and goodwill on all sides.
Yeah, the Pregnancy Discrimination Amendment to Title VII was passed through such a coalition. There is now in Congress a bill that was enacted by the House last session called the Pregnant Worker Fairness Act, which provides for the accommodation of pregnant persons in the workplace. The Senate, McConnell, blocked it so far. We don't know what's going to happen this session. But there were many Pregnant Worker Fairness Acts that preceded this at the state level. And many states have enacted these Pregnant Worker Fairness Acts through the logic of the Young case that Linda was just talking about, through coalitions of red and blue, that is, through pro-life and progressive groups, came together to support the pregnancy accommodation laws at the state level. And some of them are remarkable. You know, South Carolina has one, Virginia has one. They're not through all of the states in the South, but there are some states where these coalitions have managed successfully to come together. I looked, there's a very large coalition in support of the House bill last year, but I still saw that there's a minority report that objects and wanted religious exemptions from the Pregnant Worker Fairness Act. And I thought, okay, that's impressive, because even when the woman is trying to carry a pregnancy to term, are you going to say that you don't want to support her if it's out of wedlock? I'm not sure what the religious exemption was about there. But in any event, I'm saying that there's that possibility that I was calling the purple possibility there.
That actually brings up a question. I want to turn now to questions from the audience, and that I think is actually a perfect segue into one of the questions that was posed. The member interested to hear you unpack the case of Captain Susan Struck that Justice Ginsburg was preparing to take to court when around the time that Roe versus Wade was heard. And I know Reva's written about this case. This was a case about an Army nurse who became pregnant, and at the time there was a military policy that forced her to be discharged. The military was essentially telling her she could either quit the military or have an abortion. And Justice Ginsburg, as a lawyer, thought this would have been a preferable case to take to the Supreme Court. And the audience member is wondering if you might be able to give us at least a speculative sense of how the Struck case might have reshaped the debate over reproductive choice and what we mean by the very idea of choice, if it had been the case that had reached the Supreme Court.
So I'll say a few words about it, and then I'll let Linda chime in. So it's so they're fascinating features to the Struck case. I think it was Ginsburg's second brief in the Supreme Court. And the relevance of pointing this out one way or another is to say that discrimination on the basis of pregnancy was what she considered a core paradigmatic case of sex discrimination, not what the court, including Harry Blackmun, said, which is that it was peripheral to sex discrimination and barely a site of sex discrimination, a position which the court held until, I would say, the 90s, but that's another story. She saw it as a central case, and she was very much interested in pursuing this as a case of sex discrimination, which helped position potentially an all-male bench to think differently about the stakes of the abortion question, because the abortion question arises in this case upside down. There's a Catholic woman who wants to carry the pregnancy to term, and the Air Force is telling her, have an abortion if you want to keep your job. And this was a choice that was essentially putting enormous public pressure on a woman to end a pregnancy as the price of keeping her chance to succeed in a male workforce. And Ginsburg's brief points out that similarly situated men, that is to say, men who are about to be new fathers, were not put to that kind of a choice that women were put to. So the objection was to having a new mother, not a new father, be in the Air Force. And it was potentially because of the, let's just say, problematic to awful optics of the regulation that the Solicitor General Griswold, I think, is understood to have advised the rule to be withdrawn, and therefore the case was mooted out before it was ever argued. And as Serena was suggesting, Ginsburg long thought that this case had the potential to have differently put abortion on the court's agenda as a sex equality issue rather than as a substantive due process liberty issue. I came to write about Struck more or less at her urging. And she was concerned that the case hadn't gotten the attention that it might have because there never was a full litigation of the cause. And she fully believed in this case. And she talked about it increasingly as much of her agenda was translated into law. But this area of pregnancy discrimination remained at least an unresolved or an ambiguous area in the court's equal protection law. And I just want to say that I'm pausing to revere her, in absolute awe of her life force, her vision, her transformative role in all of our lives. I didn't always agree with her, not about everything. And in this respect, I'm not sure that the rest of the bench was ready to understand the abortion issue as she understood the abortion issue as an issue of women's roles and their equal membership. And Harry Blackmun's vote in the pregnancy cases, equal protection pregnancy cases like Geduldig and Cleveland against the Board of Education versus Lafleur, which come up right after Struck, suggests that there wasn't a sufficient number of members of that court, the Berger court, that were ready to understand the stakes of the question as she understood the stakes of the question, as sitting at the intersection of liberty and equality. Because note, the Struck case is about a woman's freedom to choose. Now we're winding up back where we started, where choice is not just simply my preference for apple pie, but where I'm stuck in a social order that values motherhood as the kind of undertaking that persons who are otherwise involved in market and political roles of consequence don't engage in. And when the world is structured in that, I don't know whether to call it male supremacist sort of way, in that hierarchical sort of way, this choice is not just any choice. It's not like a choice for apple pie. It's control over the timing of your family making processes in a way that will give you the ability to integrate in an unequal world. And she understood that. She understood that's why it was both an equality and a liberty issue. And it was a liberty and an equality issue whether women were being coerced to not give birth or coerced to end pregnancies for a variety of both class, race, and gender issues, and made that gloriously visible throughout her career. But she spent her career educating a male-dominated judiciary such that in the 90s, they could understand it differently than perhaps they did in the 1970s.
That was beautiful, Reva. I have nothing to add to that.
So speaking of Justice Ginsburg, I think one of the features of her career that isn't recognized as often is the degree to which she was influenced by international developments. And one of the audience questions gets to those kinds of global contexts. The audience member is interested to learn about how the global context around abortion rights might have affected the struggle in the United States, and how, or if and how, the US framing of abortion as a matter of choice might have had consequences for abortion rights in other parts of the world.
Oh, wow, that's a little outside my comfort zone. I mean, I'll just say, she traveled a great deal, and she totally believed that our domestic constitutional understanding benefited from an understanding of the way other societies had approached from a law-giving, lawmaking angle similar problems. But I'm not really sure the extent. I mean, so if you look at what's going on in the world today with respect to abortion, it's so infused overtly with religion, and the need in countries like Argentina and Mexico, even Italy, Spain, and look what's happening in Poland on the reverse. Countries that have to name the obstacle, which is the church. And one thing that was going on in the road time, and to this day, one thing that people don't, I think, fully appreciate about Ruth Ginsburg is that she, almost more than anybody else on the court, John Paul Stevens was the other one who comes to mind, was willing to call out religion when it interposed itself between people and their core rights. She was really a devout secularist as a matter of law, but I think in the abortion area, it's the third rail. We haven't been able to talk in public space about the fact that obstacles to abortion really are Establishment Clause violations. Justice Stevens said that in dissenting opinion back in the 80s. So maybe Reva has some more insight into Justice Ginsburg and the world with respect to abortion.
Well, I'll just say a very few things quickly. One, I want to commend to people an essay by Carrie Franklin, which is an NYU Law Review in 2009, I think, on the anti-stereotyping principle, which does trace Ginsburg's development in her early career, her time doing comparative law work in Sweden, and the ways in which her early stay in Scandinavia attuned her to the question of women's emancipation, made her appreciate the centrality of family roles to that question, modeled for her the possibility of both women and men being enabled and supported and incentivized by the state to make different caregiving choices. And this article by Professor Franklin really shows the influence of that early experience on the way in which Ginsburg develops her views about the meaning and the intersecting meanings of liberty and equality, especially around the work of social reproduction and care early in her career. Now, that story is not about abortion per se. It's my understanding, and I don't want to be absolutely, I'm not a comparativist in a major sort of way on this question, although I have written some on it, that Roe is the first decision to constitutionalize the question of a woman and a doctor's freedom to make a decision about abortion. And as the conflict in the United States heats up, it cuts across borders, and there are various other cases that come down, many of them deciding the question differently. If we were to look at Europe, there would be less constitutional law protecting of women's rights and more practical legal access in many of those jurisdictions. Partly that's because the conflict that we told the story about earlier in this Zoom discussion didn't heat up in the same way in these European jurisdictions, so that the question of abortion didn't become the lightning rod for other forms of political polarization the way that it did in the United States. But partly it's because either jurisdictions didn't address the question constitutionally, they did so legislatively, as we were unable to do. I'll bracket that for a second. Think about the UK, think about France on the one hand, or they actually had court decisions that declared that the state even had an obligation to protect the right to life, that's Germany, but which were enforced over time in such a way as to provide women access to abortion decision-making in the interests, the way these cases explain it, of protecting life. Now, what does that mean? Essentially, they take the position that if abortion is criminalized, women will be driven to make these decisions in an underground way, and the state can't be in dialogue with them about their decisions. And so in a certain number of jurisdictions, especially influenced by these German cases, there is a set of constitutional arrangements that both require criminalization, allow what they call depenalization, so all the consequences are taken away from the criminal law, and provide counseling and resources for women making these decisions, including support in a state healthcare system, so that their decisions kind of look like our Casey decision, but vindicate different constitutional values and maybe are the locus of less constitutional conflict. So how do we compare all of this? It's probably take another Zoom call.
So, yes, so we have a set of questions, I think, that center around our very current context of a pandemic that has given rise to some additional restrictions on abortion. So I'd love to hear your thoughts. We've been talking about a lot of history, and this is sort of a very present question of how the pandemic has impacted this debate, the restrictions that are feasible, and perhaps some of the more affirmative agenda that you've been discussing, how our current context might impact that going forward.
Maybe I'll start. So as the pandemic shutdown was happening last spring, one of the first things that some of the red states did was say, okay, we're shutting down abortion clinics. And these were challenged in various courts, and these were temporary measures that we're shutting down abortion clinics for the next 2 weeks or the next month. And there's a lot of litigation, and eventually those deadlines passed and kind of outstripped the ability of the courts to keep up with them. And so those all kind of fell away, but it was pretty fascinating. I mean, it was, the ultimate trap law. So, that was one thing that was happening. The other thing on the federal scale, which was quite disturbing. So there are a number of prescription medication that under the FDA label requires the patient to be handed the medication by the doctor in person or by some medical person in person. And these restrictions were lifted by the FDA on a temporary basis because the pandemic was making it impossible or at least dangerous for people to leave their homes and travel to the doctor's office. The ACOG, the American College of Obstetricians and Gynecologists, AMA, other medical groups asked the FDA to lift the restriction on medication abortion, on the 2 pills that bring about early abortions, and the FDA refused. So these medical groups went to court, and they won in the district court. And the Trump administration came up to the Supreme Court for a stay. This was early in the fall. And initially the court said, well, there seems to be some evidence that, there's some reason to grant this relief, but we're going to send it back to the district court to look again and tell the government to come up with some more reasons for why it's doing what it's doing. So it went back to the district judge. The government came back in and gave a bunch of mishmash, and the district judge reinstated his initial opinion that ordering the FDA to lift the restriction, and the Supreme Court overturned it. And they never granted it as one of these shadow docket cases. They overturned it with, I think I'm right about this, with Justice Barrett giving her vote for the 5-4. I think it was 5-4.
We don't really know. We concluded we don't really know how she voted, but we know how she voted.
That's right. Yeah. So kind of that's where we are in the relationship between abortion and the pandemic. But what's so telling about this range of activity is how abortion immediately becomes the target. The world could be falling apart. All kinds of horrible, complicated, new things could be happening, but there's still abortion, and there's still reasons why the elected and unelected officials will go, like little homing pigeons, go right for it, and that's the sad story of what we've just seen.
So we're down to the last minute here, and I just want to add to the trap law story about the nexus between the pandemic context and our abortion politics, one more frame, and that is my pro-choice life frame. So in my paper on June Medical that's forthcoming in the Supreme Court review, I could not but start the paper outside of the abortion debate, seemingly in the pandemic, by asking, how is it that the party of life has led us through a set of policies in which 500,000 Americans have passed? And I do think that it is worth looking outside the abortion context as well as in it when we're trying to understand the reasons why restrictions are being imposed. To what extent has the administration, or administrations plural in the states, that are pushing these policies in respect of abortion acted in a way that would be health protective and life protective outside the abortion context when dealing with other issues of health and life, such as those that the pandemic present? And so when I went to write about June Medical in the midst of all of the issues around the 2020 election and the issues around the pandemic, I couldn't leave the context out of the subject matter of my account, and it briefly shows up at the beginning and the end to make that painful question mark about the kind of values that we're pursuing here. And I'll stop there.
Well, I think that's a really poignant note to end on. I want to thank you both for just a really tremendous conversation today amidst a global situation and also happier family situations that you have going on today. Thank you so much. This has been amazing.
Thanks for having us.